Professor Garrett. If you want to hop in and introduce yourself,
great.
We'd love to just learn a lot about you.
Great. So I teach here at Duke Law School, where I've taught for about 2 years and a couple of months now. I had taught for some years before at the University of Virginia. When I became a lawyer, I knew that I wanted to be a civil rights lawyer. Early on, my work focused on suing police and prosecutors. I worked at a law firm, which was called at the time Cochran, Scheck, and Neufeld. So it was Johnny Cochran, Barry Scheck, and Peter Neufeld formed a civil rights law firm after their work together on the O.J. Simpson case, and then Abner Louima, Amadou Diallo, a number of high-profile police brutality cases in the New York City area. But the work there also focused on not just police brutality cases, but wrongful conviction cases where people had been exonerated by one or another of the Innocence Projects and were suing for damages for all the years they spent behind bars. And so as a young lawyer, my first trial experience was in these very high profile and unusual civil rights cases. When I became an academic, I wanted to pursue that work more and study some of the root causes. So I'll share some screens, some slides with you. Oh, I need to have hosting permission, but I'll share some images with you that give a sense of what I do and what this new center that I started at Duke does. I want to apologize for the Halloween decorations. There's a quite scary head rotating behind me. Maybe I'll move the screen a little bit so you don't have to look at it.
You should be able to share your screen now. I just made you a co-host.
Okay. Although if you'd like to see the zombie, there it is. It is pretty cool. Okay, I'll share screen. Here we go. So this is good timing. Just over a week ago, we announced this new Wilson Center for Science and Justice at Duke. There's a really wonderful video of the event, and it featured some of our work and gave a sense of the kind of projects that we work on. My interest has always been on how do we both use data, stories, research to highlight problems with and develop solutions for those problems in the criminal legal system. The center is named after the Wilson family, Derek and Gary Wilson. There's the Wilson Aquatic Center, which you may know of. That's a family that supported great things at Duke for some time. At this event, we announced the new gift, which will make it possible for the center to keep doing its work for years to come, which is really exciting, and I just couldn't be happier about that. And we also wanted to tell the story of what we do and how we do it. So we heard from a number of our collaborators. We heard from Satana DeBerry, our district attorney here in Durham County, who we've been working with on a number of projects for some time now. We heard from some folks that are working with sheriffs in North Carolina on law enforcement assisted diversion. We heard from a student, arts and sciences student, who has been helping to track data in the Alamance County Jail. We heard from another arts and science student in statistics who developed a whole website to visualize criminal debt in North Carolina and on what communities it falls. So lots of different projects, but the sort of central roundtable featured event, the keynote roundtable, I guess, was this event with Joe Bryan, a man who has not been exonerated. He's not like one of these DNA exonerees. He has not been formally cleared yet. He has been released and paroled earlier this year. And the reporter who did a lot to shed light on this case, Pam Koloff, she's a New York Times ProPublica reporter. She wrote a whole series of stories on this case titled Blood Will Tell. So if you go on the ProPublica website, the stories are really shocking and interesting. It was a rural Texas, Clifton, Texas, a ways outside of Dallas. A teacher was shot 4 times. The suspect initially was her spouse, who was Joe Bryan. His alibi was a quite good one. He was out many hours away at a high school principal's conference and said all along that he had nothing to do with this shooting. But police fixed on him as a suspect. And the Blood Will Tell reference is because there wasn't any particular evidence connecting him with the crime understandable, perhaps, that police would focus on a spouse if they had no other understanding of what the motive could possibly be. The scene had a lot of blood. There are many more gruesome images than this one. This just shows that there was spatter kind of all over the room, like you'd expect, where it's not that big a room and multiple shots are fired at someone. The police department brought in an officer who had just completed a 40-hour training course on blood spatter analysis, or BPA. Having taken this one course, this officer had never done expert work of that type before, had never testified in court about blood spatter analysis. But the expert said these uncannily precise things about the evidence at the trial. Now, it's hard, if looking at all those dots on the wall, to say something about, well, where did they come from? What direction were people sitting in? At the time, they often use strings. Well, things that travel in the air travel in a parabolic way, not in straight lines. More specifically, though, they needed a connection to Joe Bryan, their suspect, if they were going to bring a case against him. They found in the trunk of his car a flashlight, and they found some markings in that flashlight. What this expert said was, oh, that was a flashlight that was held in the left hand of the killer. The killer would have held the gun in the right hand, the flashlight in the left hand, and we can tell based on these droplets on the flashlight that they were held 46 inches from the victim's body. The victim would have been sitting on the bed. And why you would need a flashlight? Couldn't you just turn on the lights, or I don't know? The expert described how this was high velocity blood. These markings could only have come from, impact, a gunshot. And the left hand was held at an angle, pointed down towards the victim. I mean, it was really precise information that maybe it wasn't the murder weapon, but it was the flashlight that was held right next to the murder weapon. It seemed really powerful at trial. None of these conclusions were supported by any sound research. And in fact, there were other problems with the crime scene having been, lots of police officers were tromping through the crime scene. The bedding was all moved by the time this officer got there. But even if you could say something based on measurements at a unaltered crime scene, this type of stuff, 46 inches at this angle, high velocity blood, none of those conclusions are supported by research. Researchers have since said that, it's very hard to draw conclusions about blood pattern evidence. You can't say anything this precise. You can try to make measurements. It's not a well-supported method. So as a center project, I teach along with Professor Anita Farahani, who directs the Science and Society Initiative at Duke and is a fellow law professor. We teach a class where students work on these amicus briefs. And what an amicus brief is a friend of the court brief, where we are filing something from the outside on behalf of experts. So we had leading scientists from around the country sign this brief, setting out these problems with the blood spatter evidence. And in fact, the Texas Forensic Science Commission had concluded that the evidence used in this case was flawed and should not have been used in court. We set out in detail why that was, and filed this with the Texas Court of Criminal Appeals, where a post-conviction motion on behalf of Joe Bryan was pending. Didn't work. The Texas Court of Criminal Appeals denied relief without any opinion. Hopefully they read our brief and thought about it. We don't know. What did happen, though, was just a couple of months later, Joe Bryan was paroled. And we don't know whether the optics that the scientific community had weighed in and said that this evidence was totally flawed played some role in the parole decision. On its face, it was in part because of his vulnerability to COVID. And either way, he was released. We don't know exactly why. And there are efforts still pending to obtain a formal declaration in the courts that his conviction was not supported. And so at the event, he talked about what this meant to him, what it was like. He was in prison for more than 33 years. He actually celebrated his 80th birthday at our event. And Pam Koloff discussed her reporting on the case. She actually took the 40-hour course on blood pattern analysis that the officer had, and has written about just how flimsy the whole thing was and how little training or anything there was to support this type of supposed expertise. And then one of our students, Sarah Champion, is a second-year law student, when she worked on this brief, talked about what it was like to research this stuff and realized how little support there was for its use in court. And so that's just one example of one of the types of things we do. We have a big team of some full-time postdoctoral researchers, some faculty. We have a head of communications, a research director. We also work with grad students in different departments, and we highlight a couple of the grad students who we're doing a lot of work with on our website. The center, although that brief that I gave you as an example, it was a law brief filed in court. We work with quite a few folks in psychiatry at the School of Medicine on behavioral health and diversion and behavioral health and the criminal system. Many of our postdocs are psychologists who do work on accuracy of evidence, juror decision-making, eyewitness decision-making, cognitive bias and the role it plays in legal decision-making. We work with folks in the public policy school quite a bit on some of our policy reform projects. So we consider ourselves, although our home is at the law school and I'm a law professor, we consider ourselves an interdisciplinary group who try to use multiple disciplines to shed light on common problems. Here's another example. This is one of our first reports before we were with the Wilson Center, where we tracked juvenile life without parole sentencing in North Carolina. And at the time when you can do things in person, we wanted to have all the sort of a digest of what we found just on one page because we wanted to hand it to lawmakers. Here's what's going on. More than half of these sentences have already been reversed. It was always unusual in the world to have a place where you could actually sentence juveniles to life without parole sentencing. Very few other countries allow it. Today, no other countries allow it. But North Carolina's experiment, we highlighted, has been a failed experiment. When these cases have gone up for hearings, they have been reversed. And so it spent years and cost millions of dollars, but time and time again, they found that these juveniles are not the worst of the worst. They should never have been sentenced. Many of these juveniles were not even, there was a felony murder theory. There were participants, but not the primary participants in murders. These sentences are really rare today. Most of these got imposed by a handful of counties in the late 90s, basically, when North Carolina gets rid of parole and adopts these mandatory life without parole sentences for a bunch of different crimes. Prosecutors kind of go wild with this life without parole sentencing, and then they stop. And so in recent years, it almost never happens. So we highlighted all of this, but also as part of the project, it wasn't just a research project. We did op-eds, we did public education, and we introduced legislation to abolish life without parole. It got far enough that they did a cost estimate and showed that there would be real cost savings. Didn't get passed. A lot of other things are happening in the legislature during that time. We didn't have the highest hopes, but we wanted to show that this legislation can move forward in North Carolina, and perhaps it sets a precedent for more serious consideration of elimination of juvenile life without parole in the future. We do a lot of work on wrongful convictions. Certainly that's a big part of my story in terms of my interest in doing work on the criminal system, showing how the most extreme errors can occur. One thing we do is a lot of work on forensic science. Keith Harward the man with the beard, was exonerated after 3 decades in prison in Virginia based on bite mark evidence. And so unlike Joe Bryan, he was exonerated. DNA testing excluded him and linked to the actual culprit. He's been very forceful as a speaker about the flaws of improper forensics, unvalidated forensics. We also participate as part of that work. I certainly track what happens in these DNA exoneration cases. I wrote a whole book about those cases. We also do work as part of this collective called CSAFE, a federally funded consortium of universities. We're trying to do work to replace these outdated, subjective, matchy-matchy forensics with more quantitative methods. We're also looking into what do we tell jurors? People watch CSI shows. People assume that fingerprints are unique and perfect. They assume even that things like some of the studies we see, people assume that bite marks and other stuff, which we know is highly unreliable based on the few studies that have been done. Jurors still place a lot of weight on an expert who says they have some kind of a scientific background. Maybe they took a 40-hour course, but they still sound scientific. Jurors place a lot of weight on it. And so we've been doing jury studies, mock jury studies, to figure out, well, what other information can we give to jurors to cause them to think more carefully about the strengths and limits of this evidence? One thing we've shown is that if you can show that these experts have been tested and how they did on tests, that really affects jurors. They want to know, how good is this person? Are they really as, when they say it's a match, are they as perfect as they say they are? If you give them real information about that, jurors can take it into account. We also do a lot of work on eyewitness accuracy. We have a big conference coming up this fall and a big kind of national report on what's happened in the eyewitness field over the last half decade. We've done also work on how jurors think about eyewitness evidence. They place a lot of weight on how confident an eyewitness is in the courtroom. And research shows that, for the most part, people are confident in the courtroom because they've been prepared for trial. As lawyers, my job is to make sure that witnesses appear really confident about what they say in court. That's why we prepare. But courtroom confidence doesn't tell you anything about how accurate their memory was when they pick someone out in a police lineup like the one pictured there. We also do a lot of work on what we call equity in criminal outcomes, whether it's race disparities, poverty disparities, risk, other patterns in how people get treated, whether it's police stops, pretrial or arrest, sentencing, more serious consequences, as well as collateral consequences afterwards. There are a lot of different projects we're working on in the center. We are doing a lot of work, for example, on looking at how risk assessments play out. How do judges actually use these things? There are separate questions about how good they are, how predictive they are, and how fair they are. Do they cement racial disparities in prior data? Then again, we know that there are racial disparities and other unfair disparities in what judges do currently. So replacing what they do currently with something different could be an improvement. But what we have found is that there are real challenges, even if it is a good risk instrument, in getting decision makers to use them in a way that improves outcomes. We've also done a lot of work in just the last 6 months, but we have 6.5 more years to go in monitoring pretrial outcomes in Houston and the surrounding area, Harris County, Texas. It's the third biggest metropolitan area in the country. And in November of 2019, the county and a bunch of other actors, the judges, all settled a big federal civil rights case surrounding misdemeanor bail practices in Houston. And at that time, there were 40, 50,000 people a year arrested for misdemeanors in Houston. And they were routinely jailed on cash bail that they couldn't afford. Judges would follow a cash bail schedule and basically decide whether to set bail, not based on who the person was or what crime they committed. And these are misdemeanors. It's mostly petty offenses. Instead, they would just follow a schedule, and the hearings would last 30 seconds. And people who couldn't pay the bail bonds person the 10% stake, or certainly couldn't pay the whole amount, they would languish in the jail. Often they would plead guilty just to get out of the jail in these petty cases. That practice was found to be unconstitutional. There was a whole series of fact-finding and by the federal judge in the case. Ultimately, the parties all settled and agreed to new rules, which require that people for most misdemeanor offenses be released promptly at the point of booking. And then for everyone else, they have a hearing for the more serious misdemeanor offenses like repeat domestic violence offenses, repeat drunken driving. They have a more robust hearing where there's always a public defender there. There's a whole court notification system to help people both reschedule and know that they're supposed to come into court. Whole series of these provisions in this consent decree. And this isn't really a research project. I was court-appointed monitor, which means I report to the judge on whether all these parties are complying with all the terms of this consent decree. So our first report came out in early September, describing the progress so far and what the results have been. Some of the work is research. We're analyzing an enormous amount of data that we're getting from the county, which they are required to give to us. And some of the work is also more sort of policy work, making sure that they're doing trainings that reflect best practices, making sure that deadlines are being met. Just an example of what we found, there's been a real increase in the share of cases in which someone has been released by receiving bond, which is what we expected and wanted under this decree. There was a lot of interest in whether releasing so many more people caused an uptick in misdemeanor reoffending. And what we showed, we actually added more in our report. We show within 365 days, we show new felony complaints. We showed no change, or if anything, a modest decline in people who have misdemeanor complaints and then committing a new offense within 90 days, 180 days, a year, or a new felony offense, or just the numbers of new offenses people, we did not find any like predicted sky is falling, there's going to be a terrible crime wave if we release all these people. Of course, one reason why is that under the cash bail system, public safety wasn't particularly satisfied either. People would often get out after perhaps spending some days in the jail, but they would plead guilty after 10, 14 days in the jail, and they would be released pretty promptly. And there's some evidence that people who were jailed were more likely to commit new crimes. jailing people under a cash bail system caused crime because it so destabilized people's lives. To be, you lose their housing, lose their job, people's situation becomes more desperate after they've been jailed for these minor offenses. We also, I mentioned, do a lot of work with folks at the School of Medicine, and that work ranges from diverting people early on, like at the point of arrest, towards behavioral health alternatives, as well as diversion like through specialty courts, drug courts, and the like. There are real questions about how effective those courts are, or whether they work with, admit, treat the right people. Are also obviously important behavioral health needs when someone re-enters after receiving a criminal punishment. So this is, serious behavioral health challenges at every stage in the system, and with great collaborators at the School of Medicine. Some projects are kind of at the intersection. So we have students working on kind of both sides of things. We also do our own work on reentry and needs, not behavioral health needs, but other types of needs. So I mentioned criminal debt in North Carolina. We've done a lot of work on driver's license suspensions and criminal debt on the back end of often really minor criminal cases, a lot of traffic cases. People, we had 1 in 7 adults in North Carolina with a suspended license, and 1 in 12 have unpaid court debt. For the most part, if people don't pay within a year, they will never pay. So it's just an enormous amount of unpaid debt, which burdens people, can cause harm to them in terms of their rights, like the ability to legally drive. And so we've done a lot of reporting and analysis of the scale of this problem in North Carolina. This is just some of our reporting on the driver's license suspension problem. We have a big lab of students that help with this work, many in arts and sciences and in the public policy school. Law students as well, of course, since I am a law professor. We have lab meetings every Friday, and students often work in teams, sometimes with both arts and sciences students, law students, grad students, and our postdoc researchers, the full-time researchers, working in different teams on different types of projects. I mentioned this was a student project. Carolyn Levinson, an arts and sciences student in statistics, created this Shiny app with the visualization of different trends in unpaid court debt in North Carolina. And here's our website if you're interested and want to follow our work, sign up for the newsletter, look at what we do, look at our events. This is our first launching event with Yusef Salam, who I represented when I was a young lawyer, and Raymond Santana, 2 of the exonerated 5. I don't know if any of you all were here on campus when they came. It was a year before this fall, back when we could do big events in person. It was an amazing event. Those are the images I wanted to share. Hopefully that gives you a sense of the kind of collaborations that we work on at the center. I give you a sense of my work too. Not all of the center work is mine. Like we have lots of people that we work with, and sometimes students have their own projects, or the postdocs certainly have their own projects. But a lot of what I was showing you are projects that I myself am also collaborating on, co-authoring and the like. So hopefully that gives you a nice tour of the kind of work we're doing. And I'd love to hear any questions you have and talk more about what it's like to try to do work to impact the criminal system.
I have a question. I have many questions actually.
Great.
But I'm wondering, have you all done any work on the junk science of like ballistics?
We're doing a lot of work on ballistics. Well, actually not on ballistics, on firearms comparisons. So ballistics is distinct, like the paths that bullets take. We're not doing anything on that right now. We are doing work on the sort of the pattern evidence side of things, when casings or bullets are found at a crime scene and an analyst will say, I've identified it, I've test fired cartridges or bullets from this weapon, and those casings from the scene must have come from the defendant's weapon. We are doing work on that.
What have y'all found? Or is it too soon to say?
Well, we've done some work on just the overstated conclusions. In the past, they would often say, like, that bullet came from that gun, with no, in fact, to the exclusion of all other firearms in the world. And that's just not supported by research. You can't say that. They're making a comparison. There's always error in any comparison. And in fact, the studies that have been done have shown quite high error rates by the people doing this work. And so we've done some work to see whether there's a more qualified way that these experts could express their conclusions that would more carefully present evidence to a jury. what we found is a lot of the hedgy type of things that they are saying, which are a little bit more moderate, jurors assume this stuff is perfect, and basically we showed that it takes more to signal to jurors that no, this is not perfect. There are limitations here, and you need to more carefully look at the evidence. Separately, there are folks in statistics at Iowa State that are developing basically a new way of doing this, where you use algorithms to analyze 3D images and provide the jury with a number and not just your personal opinion that I've looked at the lines and the scratches all line up, I think it's a match. But the idea is to replace the human decision maker. Since we don't really know that much about how good the people are at doing this, and what we do know is concerning, to replace the people with something objective. So that's, I'm not working on that. I'm working on how can we prevent this misunderstanding and confusion based on overstated conclusions in the courtroom. We also actually just did a big survey of firearms examiners. We're still looking at the results. We're asking them, like, would you prefer to have an objective metric that you could rely on? Like, are you worried about error rates? How long do you spend working on a particular case? Just all kinds of questions about their jobs and what their concerns are. So I think that'll be interesting too. We'll have that ready in the next couple of months as well.
I could keep asking questions. So your work with Harris County is ongoing. Have you found things from that case that could be generalized out to support dismantling pretrial detention in other regions?
Yes. We also have a report coming out on pretrial reform here in Durham. And we've been looking at the jail data for a couple of years now and say some things about, I mean, the jail population has declined enormously in Durham. We say some things about why that might have happened. And it's actually hard to tease out who gets the credit because several different changes were all occurring all at the same time. We're also doing work scraping jail data from about a dozen other jurisdictions in North Carolina. Our focus, although we're collecting the data in all these different places, we're focusing on Alamance County because a civil rights lawsuit was brought in Alamance County, including by some of the same lawyers that brought the Houston litigation. And so there's a national litigation campaign to put an end to these cash bail practices. The Alamance lawsuit has also settled in a kind of a preliminary order. So a lot more may happen in the case, but that order sets out a number of really important bail reforms, including a move away from cash bail, the use of public defenders so people get good representation at these hearings. But there's also work to do to assess, well, how well is it being followed? And you can say there's a rule, but when you have, judges that have some discretion, like how do you decide whether are they really following both the letter and the spirit of the new rules? What we've been doing to help in those efforts, and it's also just interesting to us as researchers, is tracking the pretrial conditions in jail population every day in Alamance to see, like, okay, do we still see people like on some minor charge, like a failure to appear, getting high bond set and languishing in the jail? Or does it look like it's only the more serious cases where more serious cash bond is being set? Or we've been tracking all that and also providing daily digests to the lawyers in the case so they can understand better what's been happening as they have worked on this whole settlement process in Alamance County. But we hope that would have certainly many are looking to Alamance, North Carolina, as a potential model for how to fix entrenched practices. In Durham, it's a little different. Like the prosecutors, the judges, they on their own have adopted some reforms without anyone suing them. And so we're looking at that as well to see, is that more cooperative model working? We're also working on sort of distilling some of the elements of these models. So if other people want to understand, like what's happening in Houston and can we do it here? One of our goals in writing up our report was to show people what's happened in Houston, explain how it works, since that could be a model in other places. And so that's, we're thinking about what pretrial projects we might do in other jurisdictions as well. But for now, our focus is on North Carolina and Houston.
I can ask one more. Unless other people want to jump in. So during the Stand For event the other day, those folks all sort of identified as prison and criminal legal system abolitionists to a certain extent. Where would you say you and or the Wilson Center sort of fall on that spectrum, and why?
Sure. I mean, in general, we in the center agree with many or most of the goals set out by those speakers, that we think that the criminal legal system is in deep need of change, that there are parts of it that should be shrunken, defunded, that there is important work that matters to safety, but not safety narrowly conceived of as incarcerating people to stop them from doing things. And that's why we care about behavioral health services and other approaches to public problems that have really been neglected in the mass incarceration buildup over the last couple of decades, where instead we often have jailers and police officers responding to public problems and not people who are trained to do it, like social workers. We do see, though, a role that research can play to both help to test out alternatives and new solutions, and to influence policymakers and public opinion. You know, none of the speakers there was a researcher, so they were talking about the role that advocates and activists can play and the role that litigation can play. And we don't disagree that both of those are really, really important roles. It's often activists that create the public pressure and create the space in which evidence matters. I mean, I think, for example, that a center like the Wilson Center wouldn't have made sense to have the center in the 90s. What would the point have been? You could have all the data you want about how disparate, both racially and just in terms of like arbitrariness, county by county differences there were, and really, really harsh sentencing outcomes. And at the height of the tough on crime era, no one cared. I mean, really good research was done on dramatic race disparities in death sentencing. Supreme Court, with a lot of pro-death penalty justices, couldn't care less. Policymakers did not care. Right? The goal was to impose tough sentences, and there was, you know, crack war, super predator, race-based hysteria about crime, and there was high crime compared to what there had been in the 70s and 80s. People were not interested in evidence about racial disparities. People were not interested in evidence concerning rehabilitation or other alternatives to incarceration. There was no research agenda. People didn't care. In fact, people had concluded in the 70s, a lot of policymakers were like, oh, that stuff doesn't work. It's never been shown to work. The only thing that works is incarcerating people. That's all we have. And so there would have been no point to have a center like this. It makes sense now because of hard work that activists have done, that policymakers have done, change in public attitudes. All of a sudden that creates a space where research can actually inform. And it's a larger question why some topics become topics where you can have reasonable and evidence-based discussion and some don't. I mean, it used to be like 10, 15 years ago that immigration was a topic where people were open to discussion, like what should be good immigration policy? What kind of families and workers do we want in this country? It was seen as like a pretty nonpartisan, nerdy area. Lots of the law firms did pro bono immigration work. And of course now, with lots of hard right attitudes towards immigration, it's become super politicized. It's become a hot button issue. It just wasn't 10, 15 years ago. But somehow, for some reason, and who knows why, because of a lot of hard work by a lot of different people, the criminal system has moved away from being such a hot button issue. Even if in national politics, we still have this talk about, carnage in the streets. For the most part, at the state and local level, it's just not seen as something that people are horribly afraid about, that people are much more open to thinking about alternatives. And why some issues become so fraught and some other issues become ones that people can really work on. I don't think anyone exactly knows, but it does seem like exactly the right time to be doing what we can as researchers and as lawyers to push these issues. So I saw a question on prior felons and voting rights. We ourselves aren't doing any research right now on this, although we shared our data on criminal debt in North Carolina with the lawyers that were working on the felon restoration and voting rights challenge in North Carolina. And so as part of their presentation to the 3-judge panel in state court, Forward Justice and some other lawyers showed how there were these race disparities and how criminal debt falls on people in North Carolina. And that was part of their case to make, that we should not be denying former felons the right to vote because they, for example, can't pay all the costs associated with their own probation. And so our data was part of the case that they made to the 3-judge panel, and that was successful on 2 out of 3 of their claims, and they restored the rights of tens of thousands of voters in North Carolina, which was an incredible victory. You know, we had already done the research. We didn't do any work to support their efforts. We just shared our data, but it was pretty exciting to see it play a role in a really important case. In general, we're thinking about what other work like that we can do on collateral consequences, rights restoration, and reentry related work. It's doing studies of reentry is challenging. It's also, there are new challenges right now. COVID has made reentry really, really hard for people and for people providing reentry services. So there are these questions during COVID, like, do we do a study now when we know that this isn't how reentry used to work? But then again, maybe it's interesting to study how COVID has affected the situation. There are lots of questions like that where just sort of, what do we do? Given that lots of things in the system are not normal right now.
Could you talk a little bit about anything you or the center does with restorative justice? I know it's relatively new to America, at least, so it might not be common enough to have a lot of research on, but I was just wondering what you think of the efficacy of alternatives to incarceration as punishment and other ways to make restitution.
So there's a big focus on restorative justice programs, thinking about other ways of working with both victims and persons accused of crimes. And so it may be that in many cases, you know, the victim doesn't want the person sent to jail. They just want to get paid $200 for the cost of getting the tires back that they had slashed, or they know the person was homeless and wasn't in their right mind when they damaged their property. Like a apology or some community service might be all that they would expect, if anything. They don't want the homeless person put in jail for a year while they can't pay bond. Now there are real questions about to what degree should we prioritize the views of victims as opposed to the public. Prosecutors, you know, represent the public and not just victims. And but the idea of restorative justice is to bring people back to where they were before something happened. And, you know, the current system doesn't really focus on that. It's focused on meting out punishment, but not restoring people to where they were, not sort of repairing problems. And so, that said, a lot of these programs are small and are of kind of unknown effectiveness. There is a restorative justice program in Durham. It's very small. They, you know, there's not much funding for it. I think it's just a nonprofit volunteer group. They handle, you know, 5 or 6 cases a year. So out of, you know, 18,000 arrests or so a year in Durham. So these projects are very much in their infancy. And some of these concepts are really powerful ones, but how well they are funded and how well the work is done is open to question, and you really need to watch out for it. There have been, for example, a lot of focus on treatment alternatives to court, but then there are new questions like, well, what does it mean if apologies, restorative justice are part of the justice system, because it's an inherently coercive setting. It's an ethical question for medical professionals. It's one thing to provide someone with mental health care because they need it. and you're a doctor and you're supposed to be caring for people. It's quite another thing if you're providing care to someone who can't turn it down, because if they miss a single appointment with you, they're going to jail for a very, very long time. And when you attach criminal coercion to treatment, it changes the nature of the treatment in ways that raise ethical concerns and concerns about, is it going to be the same quality of treatment? What if the person doesn't need the medication, but they keep taking it every week because they know that the judge will be doing something terrible to them if they stop? All kinds of challenges when you bring things in. That's a long answer.
I would love to just ask a follow-up to what you just said, if that's okay. So part of that ties into why we know that some diversion programs end up causing more harm than good. What are some ways that you think we could responsibly institute diversion programs as alternatives to incarceration that don't end up just widening the net of the criminal legal system?
So that is a concern. Widening the net is a concern with all these changes. One challenge is that because there are often such poor social services in other settings, it's hard to divert people to some other setting where someone can get treatment, because those settings have been defunded and don't exist. And so some of these diversion programs only exist because prosecutors were able to hire a social worker in their office or a treatment provider connected with their office. And you'd think, well, ideally this would just be a community service and you'd be able to get treatment because you need it, not because you've been arrested. And why should the person be arrested be the first in line to get treatment anyway? Like there should be lots of people in that line. But prosecutors have political power and sway, and in the same way that drug treatment courts, like people with addiction needs should be able to get treatment regardless of whether they've been arrested and are facing serious drug felony charges and the like. But instead, these programs are often small and only get funded through public funding because a prosecutor or a judge wants it, which can be a good thing, and the motives can be good, but the concern, yes, is that there could be net widening, and it's more resources towards a system which really isn't the right place to be providing these resources. So that's been part of this defunding conversation. It's not about shutting down public services. It's about shutting down the use of funding in places where it doesn't belong.
I have a really high level question. You've mentioned a huge array of questions you're thinking about and topics you're focused on, and I imagine they come from all of these different stakeholders who work at the center. But I'm wondering kind of if you could talk more about the process for approaching a new topic or research project, and kind of who is motivating the question and who helps formulate the question and how that process works.
Sure. In general, we want to pick projects that we think will be novel research, potentially publishable, and also have an impact. And thinking about impact, sometimes it's because there's a partner that we're working with who's doing impressive work and we want to support it. And so we we're excited that Satana DeBerry won office as district attorney here and was planning big changes in the office. And we want to think about what can we do as researchers to look at the effectiveness of those changes, to potentially inform additional changes. And so we wanted to be also, of public service to our local community. And so, we're now in touch with some other district attorneys' offices around the country, thinking about similar work, unpacking the plea bargaining process. But our initial thought was, all things being equal, we want to help here in Durham. And so we do have a lot of Triangle area projects, North Carolina projects, because we feel like, we are here at Duke, even if none of us are physically anywhere in particular right now. Lots of us are working remotely, but, we want to be of service locally when we can. So we have a big thumb on the scale for doing projects where we can work with community leaders here. That said, if it's a project which we think could make a difference or be a national model, certainly the opportunity to work in Houston, given that was the first federal consent decree around bail reform, we jumped at that opportunity. And we do some nationally influential projects like our work on eyewitness memory or running the DNA exoneration registry. I track death sentencing across the country in a big public data collection. Some of it comes though just from the interest of our students or our postdoc researchers or postdocs that we hire, or people who want to come to a law school and a university to think about new problems, but also they sometimes have research that they were already doing as part of their dissertation, which they want to build on. And in general, they wouldn't come here unless they were interested in improving the criminal system and doing projects that can make a difference. Sometimes we know that it's going to be hard to make a difference. And so if we just shed light on a problem, try to bring public attention to it, that may be the best we can do for now. And other times, like where there really are concrete reforms happening that we can work in tandem with. But we do have a really broad mission. We can work on all kinds of different topics that have, meaning in the criminal system, whether it's, sentencing or pretrial or collateral consequences. And so we do feel like we have like amazing fortune to have a lot of freedom in terms of picking projects that we think are impactful. We also face real data challenges. And so there are topics that we would love to work on, that we've been wanting to work on, but getting the kind of access can take some time. And so for some of our projects, it took a long time to, get that information that we ultimately were able to study on criminal debt in North Carolina. As part of our Houston work, we're still 6 months in, just beginning to work with some of the data that we really need to understand some of the aspects of what's happening. It's not like, I don't know, like the data that Amazon has on every page that we look at and everything that we click on and all of our preferences and everything that we buy. Like the criminal system has really terrible data because mostly in the past, mostly what people cared about was just keeping clear what people's criminal records were so you can give them a bigger sentence if they get caught again. And so there's good criminal judgment, criminal record information, but information on how well stuff is working, on who's deciding what, are there disparities? No, not collected, not of interest. Social outcomes, social costs, not collected, not of interest. And so we often don't have what we need, and the administrative data doesn't tell the full story, which has been part of the problem for so many years, which means that to learn more about the impacts of these policies or how they're working, we have to collect a lot of data ourselves, which is hard. So sometimes, again, like getting the information we need is a real challenge. I think we only have like 3 minutes left. I saw, are there opportunities for MPPs to get involved with the Wilson Center? Absolutely. So we have paid research assistant positions. And so if there are students that are interested in doing hourly work with us, that's great. We also, students who want to do independent studies or have their own research projects, but want help with their projects, we've supported that as well. We will also, if there are projects that kind of fit within the center's mission that a student really wants to do or an MPP really wants to do on their own, but really need some funding to make it happen. They need a small amount of funding to get access to a data set or whatever it is. We're going to be beginning to give small grants to support projects where it's not in collaboration with us. It's just a separate project that someone at Duke wants to do, which we think is a good one, and we can support that as well. And we also certainly have different events and other kinds of ways to kind of just be informed or stay abreast of what's going on. But in terms of like concretely working on projects, we have way more work than we can possibly do. We've never had more students work with us. In our lab meetings, sometimes we have like 35, 40 law students, grad students, arts and sciences students all kind of joining. Probably actually would be harder to do that without Zoom, although it'd be really nice to see everyone in person. And that said, like we still can't keep up with all the different projects that we've taken on. And so we're always looking for students with different skill sets to help. In the past, we've had students, some are law students who are more legal research oriented, some are psychology, they could do psych lit reviews, help design experiments, students who are interested in qualitative interviewing skills, help with qualitative interviews, students who have design skills, help with graphics or data visualizations. So we've really benefited from the amazing variety of interest and skills that people have at Duke. And it's been a real treat to kind of bring people with the same interests, but really different perspectives together to work on these problems. So I should go. I think we have a minute left, and but if you have questions about the center or anything else, feel free to shoot me an email and I can get you connected. It was great to meet you all. The MPP program is an amazing program, and I've here and there gotten to know some of you and some of the projects that you all have worked on, which have been really, really interesting. And thank you again for including me during your lunch hour.